Any failure to completely perform when performance is due is a breach, and a breach may result in damages. This raises the question, when is performance due? The doctrine of express conditions holds that as a matter of law, performance by the party who holds the express condition does not have to perform until the express condition is completely performed. This requirement of complete performance of an express condition can lead to the harsh result of forfeiture. But equitable remedies such as excuse have arisen to soften this harsh result. Furthermore, contract law assumes that parties to an agreement will have an expectation of an exchange of promises. In other words, the law will imply that mutual promises are conditions concurrent to each other when they can be performed simultaneously. And the law will imply that one promise is a condition precedent to the other when they must be performed sequentially. If these implied conditions need to be completely performed before the other party's performance comes due, this would produce the harsh result of forfeiture in many contractual disputes. To avoid undue forfeiture, Justice Cardozo articulated the doctrine of substantial performance and material breach, which holds that the performance of one party under an exchange of promises is due when the other party has substantially performed. If a party has not substantially performed, we say that party has materially breached. The breaching party may have a cure period of time to remedy its failure, during which the other party may withhold its performance. When the cure period expires, the uncured material failure becomes a total breach, and the other party may then terminate the contract. There are different levels or qualities of performance, different types of performance and breach. In this first lesson on the topic of the effect of performance and non-performance, we'll first look at these 4 types of performance and breach and categorize a party's behavior as fitting into one of these categories. This will help us understand whether the other party has to perform or whether the other party's performance is not yet due. There is a spectrum of performance in breach, and there are 4 points along the spectrum that have legal significance. The spectrum represents the range from complete performance on one hand to total breach on the other, with substantial performance versus material breach in the middle. We'll review each of these in detail, but as an overview, complete performance means full performance of all of the obligations as detailed in the contract. Substantial performance is performance of the primary, necessary, material terms of an agreement. Material breach is a defective performance that does not fulfill the material obligations in the contract. And total breach is a condition where the partial breach has gone on for so long that it can never be cured, and therefore the other party is excused from its performance. Let's look at each of these in detail. Complete performance is the successful completion of a contractual duty. Like a pole vaulter who gets over an 8-foot pole, you have to either bring your entire body over the pole or not. It's a binary. You either made it or you didn't. You either completed the performance or you did not completely perform. Complete performance is thereby a perfect situation in which the contract was perfectly performed to its letter and completely fulfilled. The effect of complete performance is that it will satisfy any condition, whether that condition is express or implied, such that the other party has an obligation to perform his, her, or its obligations under the exchange of promises. And the party who performed has no liability. There is no breach whatsoever because the performance was complete. So the party who completely performed has no obligations to perform any further, is not liable for any breach, and can require the other person to perform his, her, or its promises. Substantial performance is a state where there has been a good faith effort to perform that resulted in the essential purpose of the promise being accomplished. even though the performance did not necessarily meet all the terms of an agreement. We might chalk this up to be an immaterial breach, where the party received the material benefit of the bargain that was expected, and the failure not to perform the minor portions of the contract were failures in good faith, not at the fault of the party who failed to perform. Substantial performance has the legal effect of satisfying implied conditions. However, substantial performance is not sufficient to satisfy express conditions. If an express condition is not satisfied, then the other party who holds that condition does not have to perform. This can result in harsh results like forfeiture. So there are several regimes courts can apply to avoid forfeiture in the instance where an express condition was not fully performed. However, the doctrine of material breach and substantial performance says that substantial performance will cause the other person's performance to be due. So if a party has substantially created a house, the other party has to pay the bill. Of course, there is some liability to the extent of the breach. The image here of the marathon runner is meant to represent completing a task. No, you didn't come in first place. And yes, maybe there were opportunities to run a little faster along the way, but finishing a marathon is a materially substantive performance. Material breach is when the material purpose of the promise is not accomplished, or where the failure to complete performance was in bad faith. However, during this time of material breach, there is still an opportunity to substantially perform. We call this a cure period. There is still time to substantially perform for some reasonable time or for some stated time, such that the party could elevate its material breach back up to the status of substantial performance, and in doing so cause the other party's duties to become due. Material breach does not satisfy any condition. The other party may withhold its performance, while the breaching party does have some time to cure. The breaching party will face liability for the breach, but depending on whether it can cure in time, it might be able to get its benefit of the bargain, such as being paid for the job. In the illustration here, the hurdler fell down, but the race is not over. It's still possible for the hurdler to get up and continue the race, and maybe to complete performance, at least substantially complete performance. Total breach is a state where the material purpose of the promise is not accomplished, and the material purpose can never be accomplished. You're out of time, the court says to the breaching party, and it would be unfair to make the obligee wait for the obligor to perform this promise. In fact, the obligee who is being harmed by the failure of the obligor to perform may have an affirmative duty to mitigate damages by hiring somebody else. So we say that there is a total breach when the situation has risen to a level such that it is no longer possible to cure the failure to perform. In a total breach, the other party gets the right to terminate the contract and, of course, sue for damages. The illustration here represents someone who never even started a race, who has clearly given up, who has quit. Yes, it's frustrating, but in fact, there is no chance that this person is going to win this race, and therefore we are not going to wait around for the opportunity to arise. Instead, we're going to declare this a total breach, and we can substitute a different runner, we can substitute a different party to perform. Total breach gives the non-breaching party the right to terminate the contract. To summarize, there are 4 states of performance and breach, ranging from complete performance to substantial performance to material breach to total breach, and each have a legal effect. The non-breaching party must perform his, her, or its obligations if performance was substantial or complete, but the non-breaching party may withhold performance while the other party is in a state of material breach or total breach. The non-breaching party only has the right to cancel the contract where the situation has gotten so bad as to result in a total breach. During the period of material breach, remember, the non-breaching party does not have to perform and can withhold performance, but cannot cancel the contract and have somebody else do the work. The other thing to remember is that in all of these states, except for complete performance, there is some liability because there has been a breach. So we want to separate in our minds the concept of whether the other party has to perform his, her, or its obligations from whether the breaching party has liability for breach. As you can see here, any failure to completely perform results in liability for breach. In our next lesson, we'll talk about complete performance, substantial performance, material breach, and total breach with a focus on their effect. So before we get there, are there any questions about the nature of these 4 types or states of performance?